In the 90s, employers were just starting to work out the status of email in workplace communications. One example came up in Timekeeping Systems Incorporated, in which the National Labor Relations Board had to sort out whether employees' emails counted as concerted activity. Timekeeping Systems was a small company that made data collection products. Barry Markwitz was Chief Operational Officer. The company had about 23 employees. Markwitz sent an email to all employees regarding proposed changes to the company vacation policy. Markwitz explained that the changes should result in employees getting more days off than they did in the present system. Software engineer Larry Leinweber replied to Markwitz that the change would in fact produce the same number of vacation days, but with less flexibility to use them. Markwitz didn't reply. Another engineer, Tom Dutton, replied to Markwitz and the rest of the company with one word of feedback, quote, "Great," unquote. Leinweber immediately emailed Dutton to explain that the proposed changes weren't, in fact, to the advantage of employees. Leinweber then sent a lengthy email to the entire company explaining his calculations. Using somewhat grating language, he said that Markwitz's statements were false. This spurred a flurry of emails among all employees. Dutton emailed Markwitz again, withdrawing his support for the vacation policy. Markwitz was angry and hurt. He sent Leinweber a memo explaining that a failure to treat others with courtesy and respect was grounds for dismissal. He instructed Leinweber to write him a message explaining why his email had been inappropriate and harmful to the company. If this message was satisfactory, Leinweber was to email it to all employees. If not, he'd be fired. Leinweber asked Markwitz for guidance and stayed up late trying to compose an appropriate message, but couldn't come up with anything. Markwitz fired him. Markwitz then emailed the workforce explaining that sarcasm and disrespect were inappropriate and that long emails wasted everyone's time. Leinweber filed a charge with the National Labor Relations Board, alleging that he was fired for engaging in protected concerted activities in violation of Section 8A1 of the National Labor Relations Act. Administrative Law Judge Ries found for Leinweber. Markwitz appealed to the board.